Good morning or good afternoon, everyone, and welcome to the second and last day of the 8th Harvard International Arbitration Conference. As we move further with the conference today, I wanted to take a moment to look back at our first day and go through a quick recap for those of you who have been unable to attend the conference yesterday. We had the immense pleasure to listen to 2 keynote speeches and 3 excellent panel discussions. The conference yesterday began with a very interesting and empowering presentation by Dr. Dietmar Prager of Deva about the role of international arbitration in maintaining peace, a very important and useful topic in the current context. The keynote speech was then followed by 3 different panels, which all highlighted the different tensions between common law and civil law traditions, first in the concept of good faith, second, in the arbitrator's powers to review contracts, and third, in the taking of evidence in international arbitration. The day was concluded with a thought-provoking keynote speech by Mr. Mohamed Shelbaya of Gaillard Bani Fatemi Shelbaya Disputes on how international arbitration stands between legal cross-pollination and legal acculturation. This second day of the Harvard International Arbitration Conference will be full of discussions and speeches that are just as exciting and thought-provoking. And I leave the floor to Sebastián to introduce today's program.
Thank you very much, Karim. Indeed, we have arrived at the final day of our conference, and you may well think that we have reserved the best for the end. Today, we have 3 outstanding panels or closing keynote speech. In the first panel of the morning, the panelists will address the topic of quantification of damages in international arbitration, with a special interest in whether there are inherent differences between civil and common law jurisdictions. The second panel, entitled Interim Measures in Commercial and Investment Arbitrations, Where Do We Stand Today, will examine different issues, including the threshold for granting interim measures, the type of remedies that can be awarded, and the risk of prejudgment, all in a comparative and a very practical perspective. The third panel of the day will analyze the enforcement of awards and the power of local courts, a topic that essentially touches upon the dual nature of international arbitration, partially decentralized, partially attached to domestic law. Finally, we will close the conference with the keynote speech of our co-chair, Dr. Claudia Anaker, entitled Investment Arbitration in the Crossroads of Civil and Common Law. Last but definitely not least, I would like to highlight that this year's conference is a tribute to Emanuel Gaillard, who was professor of international arbitration at Harvard Law School and a colleague and a friend of many people in the audience and among the speakers here. I don't think it is far-fetched to say that Professor Gaillard's longtime interest was to understand arbitration as an object of knowledge. In fact, in the final page of his book, Legal Theory of International Arbitration, he wrote that, in the same way that the purpose of philosophy is to propose an understanding of the world, theory aims to bring to light the postulates that support the institutions it examines. We sincerely hope that this year's conference will, as suggested by Professor Gaillard, shine some light in our understanding of how international arbitration interacts with different legal traditions. If, at the end of today, you feel that you now understand something that you previously took for granted, or at least that you have now a deeper and thoughtful questions, then I am sure that Professor Gaillard will have thought that the conference was a complete success. Karim, I will hand it over back to you now.
Thank you, Sebastián. Our first panel for today, as Sebastián said, will be discussing the tensions, if any, between common and civil law traditions in the awarding of damages. Our first panelist is Peter Rosher. Peter is one of the most highly regarded international arbitration lawyers in the Paris market. He is a dual qualified English solicitor and French avocat à la cour, lawyer and advocate with nearly 30 years experience in international arbitration, advising clients on contentious issues, as well as providing extensive advisory services in relation to live major projects. Peter has particular experience in international commercial and investment arbitrations and dispute resolution, with specific knowledge in international engineering, construction, energy, and infrastructure, as well as considerable experience of telecommunications, satellite manufacturing industries, and general commercial disputes. Peter also sits as an arbitrator, but for today's panel, he will be wearing the counsel hat. Our second panelist for the day is Juliette Fortin. Juliette is a senior managing director, head of France Economic and Financial Consulting at FTI Consulting. For more than 25 years, Juliette Fortin has assisted leading companies and law firms. In the context of international arbitration disputes, Juliette is regularly appointed as expert and gives oral evidence. She has been involved in more than 50 arbitrations and has testified in international arbitration procedures 20 times before the ICC and CID, French and English, and is due to testify soon in Spanish. For today's panel, Juliette will be wearing the expert hat. Our third panelist of the day is a Spanish arbitrator, Deva Villanúa. Since 2002, Deva Villanúa has been an arbitrator in Armesto and Asociados, a boutique of arbitrators with an international, independent profile in the good business sense. Deva Villanúa has been designated president of many arbitral tribunals, emergency arbitrator, sole arbitrator, and as party-appointed arbitrator in more than 50 different commercial cases. She has also acted as secretary to arbitral tribunals in more than 30 commercial arbitrations. Since 2018, Deva is vice president of the ICC Court of Arbitration. Additionally, Deva is listed on ICSID's panel of arbitrators. For today's panel, Deva will be wearing the arbitrator's hat. Thank you so much to the three of you for being here today, and I now leave the floor to our three panelists.
Thank you. Unless Deva or Juliette told me otherwise, I think the order that we'd agreed was Deva was going first, then me, and then Juliette. But I mean, I'm happy to change that if you want otherwise.
I'm happy to start, Peter,
Okay.
if that's all right. And I do have a presentation. I don't know if you can see it. Can you see it?
Yes, we can see it.
You see, it just doesn't, oops. Yes, it does move. Excellent. So thank you very much. Thank you for the invitation and for choosing this very interesting topic, which provides the opportunity to tell you a story. And it's a story about two peoples, the suspicion and the trustworthy. The suspicion, they established themselves around the Mare Nostrum, spread throughout the old land, and even crossed over the ocean to the southern new land. The suspicion have a long tradition of not trusting one another. And the starting point of any relationship is disbelief unless and until proven wrong. Many centuries into the suspicion's expansion, one leader emerged who, as an emperor, devoted huge efforts to establishing a proper legal system. So the suspicions have a codification of rights and obligations in civil and commercial operations. And so there's almost absolute certainty of what is forbidden because what is not codified as a prohibition is permitted. Good faith is an ocean to the suspicions, but it plays a lesser role. The main code of obligations does not include good faith as a primary obligation, and a breach thereof carries little consequences. And guess what font I used for the title? Yes, it's Time New Suspicion. It's a pity I cannot hear your laughter. I hope you laughed at this joke. The trustworthy, on the other hand, they populated Britannia, and they also spread abroad, mainly to the northern New Land, parts of Africa, the East Indies, and Oceania. And contrary to the suspicion, the trustworthy built their relationship on trust. And the legal system enhances this mutual confidence because there's no codification of the basic obligations in civil and commercial operations. Of course, this does not mean that it is a no laws land. There is a good number of decisions putting an end to past disputes from which one can derive what is permitted and what is not. This uncertainty as to what is forbidden pushes the trustworthy to act according to their own feeling of what is right and what is wrong, just to be on the safe side. And this feeling of what is right, also called good faith, is a big issue for the trustworthy. And many duties stem from that basic concept, and a breach of good faith duties may carry significant consequences. Do you like this story? Do you believe it to be true? If you don't, you may dissent from the suspicion. The thing is, this is just a story. It's a nice story, though, which was actually inspired by a report I read by the Inter-American Development Bank on the lack of trust and social cohesion in Latin America, and that being the cause for the stagnation of growth. But I think that there may be some truth to the story. Let's see. And now we will enter into the real topic of discussion, which is the differences, the inherent differences between civil law and common law in the quantification of damages. I think that the first difference that I see as an arbitrator is the importance attributed to the contract, the contractual liabilities and the contractual duties. In civil law, the contract is law to the parties. Obligations in a contractual relationship may stem from the contract and from the law, and the breach thereof will give rise to contractual liability. In common law, there being no exhaustive codification of obligations in the law, the boundaries of contractual and extra-contractual liability are not that rigid. And often as an arbitrator, I see that breaches of obligations which are not explicitly set in the contract are pleaded as extra-contractual liability or liability in tort. In civil law, it is very unlikely that the party in breach of a contract is held responsible for extra-contractual liability. There may be contractual, pre-contractual, post-contractual liability, but there will not be extra-contractual liability. The next difference is, I think, regarding the compensable damages. What categories are compensable? In civil law, damages fulfill the purpose of providing a proper compensation, a restitution to the aggrieved party, rather than punishing the wrongdoer. There's no room for punitive damages, and also very seldomly are moral damages awarded. These are the compensations given for mental distress or other types of intangible injury. This loss is by definition opposed to tangible or pecuniary loss, and it requires a purely subjective quantification. In civil law, pecuniary loss is almost the only damage which are achievable. The third difference is whether damages is an available remedy. And generally speaking, a claim for damages compensation is an available remedy under both legal systems. But because civil law says that any breach of an obligation carries the right to request damages. But damages is in fact almost always claimed in a scenario where the breach is material and led to the termination of a contract. So if the facts point to a breach of lesser nature, the most common remedy will be specific performance, because civil law follows the principle pacta sunt servanda, one has to oblige. And civil law perceives termination as a hateful remedy, it's an actio odiosa, and the claim for damages as disruptive. Whereas in common law, damages is not only an available remedy, but also the preferred one. Common law is more prone to letting smaller breaches go, ask for compensation, and continue with the contract. The fourth and most important difference affects the requirement of causality between breach and damages and the proof thereof. Civil law requires a very clear causal link between breach and damages, and there's little room for assumptions and hypotheses which may or may not become a reality. Common law also requires causality, of course, but it is more open to validating assumptions and is flexible in allowing other institutions, such as loss of chance, where there is by definition no such causality, but rather a balance of probabilities. Both laws contemplate two basic prongs of compensable damages, direct cost and the loss of profit. But civil law will be reluctant to award loss of profits unless there is clear proof of it, and often court decisions will dismiss claims for loss of profit as being pure speculations. On the other hand, common law is more open to estimations of the loss of profit and to the validation of assumptions. Another difference, which derives from the above, is the use of liquidated damages, forfait and proxies for the quantification of damages, which is quite usual in common law. Civil law does not like the use of these flat rates, which objectify the quantum without the need of proof of the real damage, and will empower the judge to moderate on his or her own motion when felt that the damage is disproportionate. This flexibility shown in common law in the proof of harm is of course countervailed by the requirement to mitigate damages that common law places on the aggrieved party. There is no such requirement, at least not as an express obligation in civil law. At the most, one could argue that it may be encompassed in the general good faith duty, but we already know that good faith is not the greatest value of the suspicion. And now the final question to you. Do you think there's any truth in the story I told you at the beginning? And with this, I pass the baton over to Peter.
Great. Thank you very much, Deva. Well, first of all, warm thank you to Karim, Sebastián, and the Harvard student team. Delighted to be participating. I'm very honoured, so thank you. We've just heard Deva's sort of excellent presentation and the interesting story. I'm not sure that I'm best placed to answer that because I'm a bit of a split personality. I grew up and spent first part of my practicing life among the trustworthy, and then I came across to the suspicions, and that's where I've practiced now for best part of 28 years. Deva's argument was that there are inherent differences between civil law and common law approaches regarding the entitlement to damages, and that has an undeniable degree of truth. But I'd like just to ask a question, which is, to what extent are those differences less significant in practice than they might appear in theory on paper? And so that is what I would really like to sort of challenge and scratch the surface on. And at the outset, I'll make clear that my focus is going to be on contractual damages. And I'm going to look at the French civil law system and the English common law system, simply because they're the two systems that I'm familiar with. I'm going to start as well by asking you to engage your imaginations and imagine the following scenario. A French construction startup company, the contractor, enters into a contract to expand a power plant that's situated in, well, let's say Central Europe, and that will be operated and owned by the employer. The project is intended to take 5 years to complete, and pretty soon after the project is underway, there are problems. The contractor hits delays, and the employer is unhappy with the rate of progress, and says that the contractor is in breach of achieving milestone dates, and actually the employer deducts fixed sums from payments that are being made to the contractor. The contractor then hits cash flow problems because of the late and reduced payments, and eventually the contractor decides that it will terminate and that it will remobilize its workforce on another project. And so the contractor is then looking at claiming damages for breach of contract against the employer. And those damages will comprise 2 elements. The first are the direct losses for the monies that the contractor say are owed, those that have been deducted from payments that were being made to the employer. And the second will be the lost profits, those profits that the contractor would have expected to have made had the contractor been able to complete the project. So 2 heads of damage. And then our question is, what would the contractor be entitled to recover as damages for breach of contract if the contract was governed first by English law, and second, and alternatively, if the parties had agreed that the contract would be governed by French civil law? So let's start with some basics. The basic rule under English law is that the claimant, here the contractor, is entitled to recover so as to put it in the same position that it would have been in if it had not sustained the wrong. French law recognizes the principle of full compensation, as Deva mentioned, and the objective of that is to put the injured party in the position it would have been in had the act that gave rise to the damage not occurred. So we can say that the contractual damages in English law and in French law share the same objective. Under English law, damages for loss in a breach of contract claim are available as of right. Damages constitute the principal remedy that is available for a breach of contract, and it's only in exceptional cases that damages would, or rather that an award of specific performance would be granted. That is where damages would not be an adequate remedy. So specific performance is an equitable remedy in English law, and it will only be awarded in exceptional circumstances. French law, on the other hand, favours specific performance over damages unless specific performance isn't possible, or there is a manifest disproportion between the costs of specific performance for the debtor and the creditor's interest in specific performance. And if the aggrieved party has requested specific performance from its debtor, and if the debtor doesn't comply, it's only then that the debtor can be liable for damages. That's the theory. So unlike common law, where damage is the principal remedy and specific performance is very much the exception, French civil law starts by considering that specific performance is the primary remedy, and consistent with that emphasis on specific performance under French law, the claimant must give notice, a formal notice, to the respondent that it's in delay or in breach of contract, and request performance of the obligation within a reasonable time, unless non-performance is permanent. And if the respondent doesn't perform upon receiving notice, then the claimant will be entitled to damages. Seemingly very different approaches, very different indeed. But despite this general rule regarding specific performance, in practice, the vast majority of cases that I have come across where French law has governed and been applied by arbitrators are compensated by monetary damages. And damages is the more appropriate remedy. And in the scenario that we looked at the beginning, it would be the compensatory damages that would be of real interest to our contractor, not specific performance. So that's one myth, perhaps a little, well, nuanced. Very different on paper. In practice, parties want the same thing. They want to be compensated in money, in financial terms, for their loss. So if we turn now to look at the rules for establishing the entitlement to damages, the burden of proof under both English and French law lies with the party making an assertion. And as regards the standard of proof required, under English law, it's on the balance of probabilities, so it's more likely than not. And under French law, there is no specific standard of proof, and the French judge or an arbitrator applying French law has very wide discretionary power. But ultimately, in practice, it will come down to the same thing, and that is that the evidence adduced must be sufficiently compelling to convince the judge or the arbitrator of the claiming party's position. And before quantifying damages, the claimant thus has first to satisfy that burden or that standard of proof by establishing that it's entitled to damages. And under English law, this means proving a breach of contract first, the breach. Second, the causal link between that breach and the damage that has been suffered. Thirdly, that the loss that occurred was not too remote, so that the chain of causation has not been broken. Fourthly, that the loss that occurred was reasonably foreseeable by the parties at the time that they entered into the contract. And English lawyers, every English lawyer you speak to, if you say the words Hadley and Baxendale, they will know precisely what that means. It's a case that is now 160 years old, but that is still very relevant when you are looking at how you go about determining a party's entitlement to damages under English law. And Hadley and Baxendale set down a two-pronged test. And in essence, loss is recoverable only if the type of loss that occurred is in the contemplation of the parties, i.e. is foreseeable. At the date of contracting, so it's the date of the contract, it's not the date of the breach that is operative. And the Hadley and Baxendale two limbs, the first limb is sometimes referred to as direct loss, and that is damages that flow naturally and according to the ordinary course of things. So the sorts of damages that you would expect to flow very naturally from a breach of that specific obligation of the contract. And indirect or special loss, which covers additional loss contemplated by the parties at the time of the contract as the probable consequence of a breach. So this is where parties have actual knowledge of special circumstances outside of the ordinary course of things. So the parties are going in, they have their eyes wide open, they know that there are particular risks with this contract and particular types of loss that are outside the normal course of things, but they both know that at the time that they've entered into the contract. So under Hadley and Baxendale, you would be able to recover that as part of your damages. So let's apply English law to our scenario. The money's not paid, so the direct loss would be recoverable. They'd be recoverable under that first limb of Hadley and Baxendale. The lost profits, well, they should be recoverable, logically, provided that the evidence is provided, also under that first limb of Hadley and Baxendale, because it's reasonable to expect that sophisticated parties entering into this type of contract would have expected that if there was a breach, one of the parties would have been denied the profits that it could reasonably have expected to make if the contract had been performed correctly. So prima facie, you could recover both. So now let's turn and look at French law. Well, French law goes down a different route, but essentially I think it arrives at the same destination. And the damage must be certain and direct and immediate as a consequence of the breach. These are the tests that are applied under French law. So losses must be certain doesn't mean that future losses cannot be recovered, provided you can show that they are certain to be incurred in the future, and they may also be a loss of chance or a loss of opportunity. So if we apply that to our present case, the contractor should normally be able to demonstrate that his direct losses, the money that he was not paid, that was reduced from the progress payments that were being made, are due and owed to him as being certain, provided he has the evidence to prove that. As for the loss of profits, there the contractor may be able to demonstrate the certainty of his losses Although that might be a little more difficult, and might be more difficult because remember, this contractor, it was a startup contractor for a new project. So that contractor may have more problems actually providing evidence to show what kind of profits they would have expected or could reasonably have expected, and based on a track record that they already have. So you would also have some of those evidential issues under English law. But they may well be able to recover the loss of profits, even if French law applied to this particular contract. So I said there are two elements. So it's certain, but the losses must also be direct. And this means that there should be a causal link between the breach and the loss. And French judges and arbitrators applying French law have significant discretion in appreciating causation, and they apply different theories of causality depending on the circumstances of the case. But I think that they are likely to arrive at the same conclusions as an English judge or an arbitrator applying English law in the particular case scenario that we were looking at. And it's likely that direct losses would satisfy the requirement of being direct. And I think that the employer may well be able to demonstrate that the contractor the contractor may be able to demonstrate also that the loss of profits would have been direct, unless, of course, the employer can demonstrate that being a startup, the economic model, there isn't sufficient documentation or evidence to show that that was a reasonable assumption on the part of the contractor. So you're going to get into an evidential, factual battle, but you'll have that battle, whether it's an English law or a French law dispute. So different routes, arguably the same result. Let's now, Deva mentioned the concept of mitigation, and that's something that in common law jurisdictions, including England, would enable an aggrieved party, it would require, an aggrieved party to be under what's referred to as a duty, and I'll come on to that, to take steps to minimise or at least not increase its loss. So damages can be reduced if a party has not taken steps to mitigate its loss. And the philosophy behind that is that, a party says that the other party's in breach. They can't simply just sit back, do nothing, and let the losses accumulate. If they could reasonably, for example, it was for a supply of goods and they could have gone out onto the market and acquired those goods at a reasonable price, and therefore they could have mitigated their loss. So that's what it's designed to do. And I'm going to make a number of observations in relation to mitigation of loss under English law before turning to look at whether or not that exists under French law. The first point I'm going to make is that it's not technically correct to call it a duty of mitigation, although you'll see it referred to that a lot. You don't incur any liability if you fail to mitigate your loss. So how can it be a duty? The claimant is free to act as it wishes. What happens is that if you don't take steps to mitigate your loss, then you will be unable to recover that portion of the loss that is attributable to the failure to mitigate. But you can sit back and do nothing, you just pay the price because your losses will be reduced. Second point is that where the claimant has minimized its loss, the damages owed by the respondent are reduced by the amount of the reduction achieved. Third point is that any profit that is accrued as a consequence of the claimant's mitigating steps must be credited to the defendant if causation is established. Now imagine that we had a supply of goods and there was a breach of contract, and the aggrieved party went out onto the market and it managed to get the goods at a much better price than was the price under the contract. Then logically you can get into a situation where you've actually mitigated your losses, but you've ended up with no loss whatsoever. And the burden will be on the defendant to prove both the existence and the amount of the profit. Now, there's been quite a bit of criticism also over the years of this concept as a matter of English law, because we spoke earlier about putting the aggrieved party into the position it would have been had the contract been performed. And there's been quite a bit of criticism that what this does effectively is it doesn't allow a party full recovery. and that it's policy driven. And we'll come on to see, because that's a criticism that's been levelled as a reason for not imposing a mitigation duty under French law or other concept. So in our case scenario, the employer could possibly argue that the contractor should have made efforts perhaps to remobilise his workforce onto another project, rather than just sitting back saying there's a breach and his losses are going to accumulate, and would be looking at other ways of showing that the contractor should have been reducing its loss. So if we now look at French law, and in France, like a number of other civil law jurisdictions, they haven't embraced a concept of mitigation. And I mean, this part of the explanation for this may well be that we saw earlier that specific performance is the primary remedy, not compensatory damages. So they haven't really had to grapple with that particular thing. If specific performance is your primary remedy, then you're not going to be worrying about mitigating compensatory damages. And philosophically and historically, I mean, French legal tradition has been quite vehemently at times opposed to this concept, and they say that it actually contradicts the principle of full reparation of losses, and that it appears to infringe the rights of the victim, the aggrieved party. And French legal scholars have considered that the Anglo-Saxon principle is an expression of the enslavement of the law to the market and the preeminence of a pragmatic mercantile vision of the world. A criticism that has actually been echoed on the other side of the channel by some legal authors as well. I think it's a space that we need to watch, because things may change. At the moment, there is a reform or a project for reform of tortious liability. So it's not contractual liability, but in its latest version that was commented before the Senate in 2020, it included the possibility for French judges to reduce the damages paid to the victim when he or she has not taken safe, reasonable and proportionate measures to avoid aggravating the injury. Now that smacks of mitigation of loss. As I say, it applies to tortious, not contractual, but if it's recognised in tortious liability, I think the debate will become much more live as to whether or not you can transpose that across for contractual liability. So as I say, a space to watch. And I'll go a little bit further and I'll say, in any event, mitigation gets in via the back door, even though it can't get in the front door, in French law sometimes, because there have been judges who have taken into account the aggrieved party's inertia in assessing the damages. And so they've said that the aggrieved party couldn't just sit back and do nothing, and they've taken that. And because French judges have a very wide discretion, they are able to do that. There's also been reference, I couldn't find any case law, but I only started looking for that a little earlier, so I should have taken more time. But I have seen authors, some of the legal scholars, writing about the implications for the obligation of good faith as well in achieving what would effectively be a mitigation of damages concept. Another thing to note, and I have seen this in contracts governed by French law, is that the parties can provide in their contracts that mitigation applies, and that wouldn't contravene either French law or French public policy, so that's possible. So I think, you know, we can see that while there are differences in the approach to compensatory damages, in practice, you often will arrive at the same result just by different routes. Now, it's important, obviously, if you're applying French law, because that's the law that's been chosen by the parties, or English law, and if you're before, you know, French lawyers or French professors or English, that you understand the logic that they will be applying, and that you take the right road effectively in achieving that result. So that's obviously important, but I think the practical effects, and I've seen this in the course of my career, often that you would achieve the same level of damages whether you were applying English or applying French law. Now, that's not to say that there aren't some pretty fundamental differences in some respects, and Deva mentioned one, which was liquidated damages. And you see liquidated damages clauses in big construction infrastructure contracts. They are used as a tool that allows the parties to allocate risk. and whether the contracts are governed by French law or governed by English law. You can see those. It's a clause that provides for a fixed sum payment in the event of a non-compliance with a particular obligation, such as timely performance. So it's a pre-assessed damages for a specified breach. And it's of benefit to both parties to a contract, both to a contractor and an employer, because it avoids them having to go into the time and the expense of proving losses, which is notoriously difficult. So they do away with having to prove causation, having to prove remoteness. They don't need to worry about mitigation. That's all irrelevant because the parties have contractually set the level of damages that will be available for a specific breach. Breach happens, that's what you get. You don't need to go to the time and trouble of proving anything. English law, liquidated damages clauses are valid, provided they are compensatory and objective, and they do not operate to penalise the offending party. And the law has been refined in the last years, but it's still the case that what you would be looking to show effectively is that when the parties entered into the contract and they set that level, the liquidated damages, they were doing it on a rational basis, setting some a genuine pre-estimate of the likely losses for that breach. And that's what they're seeking to recover. You come the other side of the channel, it's very different. You have what can be called a clause pénal. It can serve a punitive deterrent objective, and that's perfectly legitimate, and that's what happens. And it's designed essentially to put pressure on the other side to fulfill the contract. French law will mitigate the apparent harshness of that rule by providing the judge or the arbitrator applying French law with the power to moderate and re-evaluate a penalty clause if the amount is manifestly excessive or manifestly derisory. That is used pretty reluctantly by French judges, to be honest. English law, on the other hand, is more rigid. If the liquidated damages provision is determined to constitute a penalty clause, all that an English judge can do, or an arbitrator applying English law, is strike down that offending clause entirely. They do not have any flexibility, like a French judge or an arbitrator applying French law, to adjust the level of the liquidated damages in circumstances so that it's set at a more reasonable level. Now, there's been some great articles. There's one by Doug Jones, who is now suggesting that we should be looking in common law jurisdictions at introducing this mechanism to enable arbitrators in international arbitrations applying common law laws to have this ability not to just strike out a liquidated damages clause altogether, but to actually find some more reasonable level. And frankly, I find that quite an attractive proposition. How am I doing for time, Karim? Juliette? Well, I think I was going to go on to say a little bit about quantification, which is driven by a factual determination and involves complex data and economic issues. And that's why parties and their counsel rely on experts and expert evidence. So perhaps actually that's a good segue to hand over to Juliette.
Thank you, Peter. Thank you very much. So further to Deva's very nice story, which I like very much, and Peter's very interesting points. What I want to share with you today is some points that I want to explore with you based on my expertise and my perspective as an expert, a quantum expert, and based on my knowledge. Of course, I'm not a legal expert, so please forgive me if I don't use the right word in a legal system, etc. So first of all, I want to give you an overview of, in my experience, how each of the legal system uses the quantum expert. And I will rely mainly on the French system for the civil law and English system for the common law. So let's start with the procedural aspect. The involvement of the expert witness extends beyond the usual role of the witness in that they are not simply present to tell a story as the fact witnesses, but they are expected to give opinions and detailed explanations on the meaning of the usually complex financial evidence presented to the trial or the tribunal. So the expert interacts far more with the evidence than would a fact witness, for example. They will use it, measure it, interpret it, and describe it from a position of authority. In the common law system, the tradition is that the parties will appoint the expert in a similar way to the appointment of the advocates, whereas in the civil law system, it is most common for the expert to be a court or judge-appointed expert. The courts will often select the experts from lists, which are published by the Courts of Appeal or the Cour de Cassation, and the judiciary experts are typically listed into different subcategories depending on their respective area of expertise. In the French civil court proceedings, when a party-appointed expert witness also happens to be a judiciary expert, he or she will be bound to some principles set out in the Code of Conduct of the so-called National Council of Judiciary Experts, Conseil National des Compagnies d'Experts de Justice, professional body that oversees the profession. The Code of Conduct provides undertakings related to the independence, the objectivity, as well as other peripheral obligations. In the French civil court proceedings, there are at present no specific requirement for party-appointed experts regarding their duties or obligations, although some expert witnesses will typically include a declaration of independence in their report confirming their objectivity and overriding duty to the court. The expert witness plays an essential role in a significant amount of litigation matters in common law proceedings. Indeed, without the contribution of the expert reports and testimony, the litigation would not be possible from the quantum point of view. And differently to the civil system, as Peter was saying, here the judge will have a large discretion on the amounts to be awarded, if any. The weight of the oral evidence is also far more important in the common law system as regards to expert evidence compared to the nearly nil weight of the oral evidence in the civil law system, at least in the French system. I've never been called personally to testify in French procedures, contrary to international arbitration, which are more mirroring the common law as regards the use of experts. Another difference that I find between the two systems regarding the use of experts is the way the evidence is used. On the one hand, the expert opinion in common law system or in international arbitration is scrutinized. The judges will not hesitate to dismiss an expert opinion if they consider that the expert is biased. I was reading a UK court judgment with very strong words regarding one expert's independence or lack of independence, saying, you know, there are other examples of his or her wholly unhelpful approach. The evidence of Mrs. X was far more balanced and independent than that of the other expert, etc., etc. On the other hand, in the French system, for example, the French judges would not raise such criticism vis-à-vis their judicial experts. Judges will often, more often than not, use their discretional power to assess the damages, as we said before. So, in my experience, the judges in France also presume that the party-appointed expert is not independent and is really an advocate, contrary to the fact that this presumption of independence is very important, for example, in the UK court, as well as in international arbitration matters, where you would always put as an expert a declaration of independence and of overriding duty to the tribunal. So we as experts have to adapt to the legal system of the case Having said that, in my experience, those differences in the role and the use of the expert, which can be seen in judicial courts, are actually much less significant in international arbitration, whether the law is from civil law or common law systems. And this is something I have come across as a very common way of using the expert and their role in international arbitration over the past 15 years. Now, just turning over the overarching principle of the damage assessment, we are here in the case where there is compensation through the assessment, the awarding of damages. Well, as an expert, you will turn always to the very principle of the full compensation. So you would rely, for example, on the famous Chozo factory case, where it is explained that the reparation must, as far as possible, wipe out all of the consequences of the illegal act and re-establish the injured party in the situation it would have been in had the act not been committed. In civil law, it's very similar. Peter mentioned it, full compensation, really to restore as exactly as possible the balance destroyed by the damage and put the victim back in the situation it would have been in had the harmful act not taken place. Well, all of this from the expert point of view goes back to the same thing, and there is no difference between common law and civil law for us expert. It's going to be a comparison between two scenarios. The actual scenario where the position, which is the position the claimant is actually in, given the effect of the wrongful conduct, and the but-for scenario, which is the position the claimant would have been in but for the effect of the wrongful conduct. So in applying this but-for analysis, the quantum expert needs to consider a number of factors. Peter mentioned the mitigation. There is also, we need to understand the relevant categories of the losses that can be awarded in order to make sure the assessment fits into this legal framework. And also we need to understand the level of certainty that is required under the legal framework. In terms of mitigation, I don't want to repeat what Peter mentioned, just wanted to give you an example of concretely what this mitigation factor entails from an assessment of damages point of view. So here, want to talk to you about a dispute that occurred between a Thai airline and an aircraft seat manufacturer called Koito in 2015. In this case, Koito had agreed to supply Thai Airways with aeroplane seats, which Thai Airways had planned to install into 5 new planes that it had already purchased. However, Koito failed to deliver the seats, and as a result, the Thai Airways was unable to install its new aircraft at the anticipated time. Pausing the story there. So in a jurisdiction where there is no duty to mitigate, as mentioned Peter earlier, the quantum of damages might solely be calculated as the lost profits arising from the delay experienced by Thai Airways in getting its new airplanes off the runway. However, in this particular case, the duty of mitigation applied, and Thai Airways in fact leased an additional 3 planes to stand in for the 5 inoperative planes. In these circumstances, the quantum expert would need to increase damages for the cost that Thai Airways had incurred in taking reasonable steps to minimize its losses and decrease the damages by the benefit of the mitigation achieved. There are 2 further issues that might arise, which were not present in this case. First, if Thai Airways had not taken steps to mitigate its losses, then the damages could still be reduced to account for the mitigation duty. And second, the mitigation steps taken by Thai Airways can be described as being active steps. However, in certain circumstances, the expert might also need to consider whether the claimant has avoided taking unreasonable steps that increase its losses. Now, moving very quickly, as I can see that time is running, on the categories of recoverable losses. So here, still under French Civil Code, you have the two concepts of the losses, which are damnum emergens and lucrum cessans. And in common law system, I will talk a little bit about expectation losses versus reliance losses. So in the civil system, the damnum emergens really addresses any cost incurred as a consequence of the breach or as the wrongful act. So it's really talking to, in my experience as expert, about the actual extra costs that were incurred. Whereas the lucrum cessans would be related to the lost profits, the profits that were not made because of the wrongful act. This, so the two categories added together would match what in common law we call expectation losses. Expectation losses aim at putting the injured party back in the same position it would have been in had the contract been properly performed. In that sense, as I was saying, that matches the loss presented as damnum emergens plus lucrum cessans. And it's important to understand that this objective of expectation damages differs from the reliance damages, where here what we are aiming at assessing is the amount that would aim at putting the injured party back in the position it would have been in had it not entered into the contract at all. So that's very different. On the expectation damages, we build the scenarios as if the contract would have been performed normally. And in the reliance damages, we build the scenario as if no contract had been entered into. Two comments on these expectation losses and reliance losses. Although the forward-looking approaches, meaning the use of discounted cash flows, for example, or market-based approach, are sometimes seen as the only possible approaches to meet the full compensation standard for an expectation loss, well, this is not exactly true. Backward-looking approaches, wasted cost approach, might also be relevant in some circumstances. For instance, in the absence of strike record that could prevent projecting cash flows with a sufficient level of confidence, the DCF method might be disregarded. It is also possible that market-based approaches are not relevant because there is no such market comparable. So that's important to bear in mind. Backward-looking can be the good measure for full compensation in expectation losses. Second comment on that, both the forward-looking and backward-looking approaches can ensure full compensation. The appropriateness of each approach, in fact, depends on the claimant's ability to show that the contract overcompensates for the residual risk borne as at the valuation date. Such demonstration is easier with the passing of time when hindsight allows to show that some of the ex-ante risks that were factored into the investment price did not materialize in actuality. Finally, I want to just touch very briefly on the use of the backward-looking approach, which can be challenged differently, whether it's in an expectation framework or reliance framework. If the wasted costs are claimed as a compensation for expectation damages, the underlying assumption is that the wasted costs are a good proxy to assess the fair market value of the lost profits that would have been generated from the investment. That means that the injured party should be able to demonstrate that the expected profits from the project would have recouped the initial investment. This test is not necessary if the wasted costs are claimed under a reliance loss framework. because there the underlying assumption is that the wasted cost should simply put the injured party back in the position it would have been in had it not entered into the contract. Finally, the use of the wasted cost as a proxy to the calculation of lost profits might be barred by the contractual clause that might exclude any possibility for lost profits. This might be the case if there is a liquidated damages clause and the exclusion of lost profits, for example. So I'm going to pause here because I'm conscious of time. There's many things to say on the common law versus civil law differences in the assessment of damages. But as Peter was saying, in theory, there are differences, etc. But in practice and in the financial perspective, what is most important is really to compare the correct scenarios that fit into the correct legal framework. So that's where the conversation between the counsel and the expert is very key at the very upfront of the case to make sure the expert is working on the correct legal framework.
Thank you so much, Juliette, Peter, and Deva, for this very, very interesting panel discussion. It was very interesting to hear the three different perspectives you each exposed. I think that we have 5 minutes left, so I'm not sure whether you have questions for each other, whether the audience has any questions to ask.
I'm happy to answer any question. Is it possible for the audience to submit questions?
It is possible for them to insert questions in the comments section. If you have questions for each other, we're happy to take them.
Okay. Maybe one point that is worth emphasizing is that we're talking about common law and civil law. Both Juliette and myself were looking at England and France because they're the ones that we're most familiar with. But of course, even within each of those families, common law and civil law, you can get some divergences in the way that, for example, Australia and England approach certain issues, including liquidated damages, for example. So you've got to be conscious of that. And you need to work with lawyers that are qualified in that particular jurisdiction. And the same, of course, with civil law as well.
Thank you so much, Peter. On behalf of the entire executive board of HIALSA, I'd like to thank the three of you for accepting our invitation. We were very happy and honored to host you for the 8th Harvard International Arbitration Conference and look forward to having you in our upcoming events in the near future. I think we have a 13 minutes break and we will gather again in 13 minutes for the 5th panel, which will be discussing interim measures in both investment and commercial arbitrations. Thank you and see you at 10:10 EDT.
Thank you, Karim. Thank you, Sebastián, for the invitation.
Okay. Thank you very much.
Bye.
Bye.
Welcome back, everyone. We're here in the second to last panel of the 8th Harvard International Arbitration Conference, entitled Interim Measures in Commercial and Investment Arbitrations, Where Do We Stand Today? For this panel, we have three truly outstanding speakers. First, we have Mr. Philippe Pinsolle. He is a partner at Quinn Emanuel, where he's the head of international arbitration for continental Europe. He has over 25 years of experience as counsel, expert, and arbitrator in international arbitrations. He has acted as counsel in more than 300 international arbitrations, with a particular focus on investor-state arbitration and commercial disputes involving the energy, power, oil and gas, construction, and defense industries. Philippe holds an MBA in addition to his dual legal qualifications as a French attorney as well as an English barrister. We also have Isabel Fernández de la Cuesta. She's a partner in the International Arbitration Group at King & Spalding, based in New York City. She has more than 17 years of experience advising clients in complex, high-profile, and high-value international disputes, both commercial and treaty arbitrations. Several publications have recognized Isabel as a future leader in the partner level in international arbitrations, as well as a rising star. And finally, we have Rafael Rincon. He's a partner at Zuleta Abogados, where he focuses his practice on international arbitration, international litigation, and public international law. He has worked in arbitrations under the rules of the ICC, ICSID, ICDR, and UNCITRAL rules in disputes involving infrastructure, energy, construction, transportation, and the oil and gas industries, among many others. Rafael also sits as an arbitrator in domestic and international arbitrations. Prior to joining Zuleta Abogados, Rafael worked in a large regional law firm in the New York office in Latham and in the New York office of Latham and Watkins. With this, Isabel, the floor is yours.
Thank you so much, and it's my pleasure to be here. Thank you for inviting me to this really wonderful conference. I'm really honored to be here. Without further ado, let's start our panel today. We have a lot of ground to cover, and we could be speaking about interim measures the entire day. So let's just dive in with the ultimate question for Philippe. I'm going to put it to him. Let's do the reality check. In your experience, do interim measures work? And do they make a difference to the parties that are seeking them? You're on mute.
I'm on mute. So how do I mute?
Yes, you're.
Is it better? Can you hear me now? Yeah, good. Okay. So yes, interim measures work. And I'll say four things about that. First, the reason why they work is because essentially they impress the tribunal very early on. But before that, empirically, we know that they work because we see a considerable increase in the number of requests for interim measures. I see that in my practice, but if you think that it is too empirical, maybe you could consider the various institutions. They have all modified their rules recently over the last 15 years to introduce an emergency arbitrator. As you know, the emergency arbitrator is the arbitrator that is appointed to render interim measures before the constitution of the tribunal. This is a general trend. That trend corresponds to a need of the market and of the market players and of the parties to arbitration. So why do they do that? They do that because notwithstanding some semantic precautions, as you know, for example, the ICJ can only indicate interim measures and ICSID tribunal can only recommend interim measures, while tribunals operating under other set of rules can order interim measures. But in practice, it's the same. It is a decision by either an emergency arbitrator or the tribunal, generally at the beginning of the process, which has some bearing on the parties' rights. And of course, you can disregard it, but generally it is a bad idea to disregard a decision of the tribunal at the beginning, especially if it is the tribunal that will judge the merits. If it's an emergency arbitrator, you can maybe run that risk with the additional risk that the measure may be confirmed by the tribunal if and when the tribunal is constituted. So generally speaking, empirically, we see that these measures work and they impress the tribunal, they impress the parties. So two things about that, two remaining points. One, we see rules modified, two, measures work in general. Three, as a result, the parties are using interim measures with a view to gaining a tactical advantage. We see that a lot. For example, you may want to focus the tribunal's attention at the beginning of the process on one aspect of the case that is good for you. That aspect of the case will depict the other side as the bad guys. You will be the victim. And if you can frame this into an interim measure application, after all, whether the interim measure is granted or not is irrelevant to you, because what you have done is that you have sort of implanted in the mind of the tribunal the notion that you were the victim of some sort of injustice. And maybe the interim measure will be awarded, maybe it will not be awarded, but nonetheless, you have a tactical advantage. So, of course, I'm not saying that all interim measure requests are tactical. Most of them are actually legitimate. And even the tactical use, in my view, is legitimate in some instances. But nonetheless, there is this tactical dimension which we see a lot today. So you ask me, what is the impact? I would say that the impact of an interim measure can be sometimes, I wouldn't say decisive, but maybe partly outcome determinative. And I'll give you 3 examples of this type of measures which have had an impact on the outcome of the case, based on real examples or based on hypotheticals which we find in some industries. First, investment arbitration. As you know, in investment arbitration, you generally have an investor which is disgruntled by the behavior of the state. That investor will very often have principals, physical persons behind the investment. Whether they use a vehicle to invest or not depends on the case, but very often there are principals. And when things go really sour between those individuals and the host state, it is not infrequent that the host state will use the full powers of a state to, let's say, fight what is viewed as a fight, precisely. So you have states enacting certain measures which are only available to states. For example, criminal measures. You start criminal measures against the investor or the investment. That is available to private parties, of course, if the prosecutor is happy to prosecute the case. But states go further than that. They can issue arrest warrants. They can issue Interpol red notices. As you know, an Interpol red notice is a flag on you, which is sent to Interpol in Lyon, in France. And then all the countries that are members of Interpol are supposed to arrest you if and when you cross a border. So adding an Interpol red notice on your name, with your name on it, is a very serious problem for any individual. Not to mention the fact that your bank account will be immediately closed and no bank will want to have you as their client. So it is a serious problem. Now, sometimes all these measures, of course, are entirely legitimate. And I would say most of the time they are. And these powers are intended for state to fight criminality, to fight terrorism, and as a result, we see no difficulty with that. But sometimes they are used with a, let's say, with a view to retaliating against the investor. And this is where an interim measure can help. There is one example of this in the Exit case, Hydro and others against Albania. I was involved in that case, so on behalf of the investor, but nonetheless, it's probably the most topical example. In this particular example, Albania had commenced criminal proceedings and had issued an extradition request against an investor that was residing in London. The Exit tribunal that was in place was persuaded that these were retaliatory in nature and issued an interim measure recommending that these various processes be suspended. Albania did not comply with it immediately. It went to the English court pursuing the extradition, and the English court said that this was an abuse of process for two reasons. One, they lied about the content of Albanian law before the English court, but also it was in disregard of the ICSID interim order. So you see there the impact of the interim order. That case eventually resulted in a 110 million plus award, which was maintained by an ad hoc committee and which is being enforced. Without the measure, the extradition proceedings would have been carried out. Maybe the investor would have been extradited to Albania, and maybe that person will still be in jail today. So we have a situation where clearly the measure has had a decisive impact. Second example, a classic example of construction disputes. So we are in commercial disputes now. And as you know, most big construction contracts do have performance bonds, sometimes with significant amounts attached to them, sometimes hundreds of millions of dollars, generally 10% of the amount of the project, but sometimes it's 15%. And when a dispute arises, the first thing that the owner is tempted to do is to draw on the bond, which may or may not result in the contractor being in a difficult situation. So that situation arises very frequently, more and more recently, I would say. And tribunals, sometimes, not always, but sometimes, tell the owner, no, please, you do not draw on the bond pending the arbitration. And then they tell the contractor, please, you extend the duration of the validity of the bond pending the arbitration. So I maintain the status quo pending the determination of the dispute before me. That's the tribunal. And often, not always, these measures are complied with. Sometimes, of course, the owner is disregarding the measure at its risks, but here we see a measure that is intended to enable the proceedings to continue with the status quo. And sometimes, if the measure is not complied with, the contractor can go bankrupt, which of course complicates the rest of the arbitration. So here again, classic interim measure, do not draw on the performance bond, consequences that are very significant on both parties, especially on the contractor. Last example, and then I'll stop. The type of measure that will put an end to the dispute, or at least for a while. 3 words: security for costs. Security for costs is a measure which takes the form of an interim measure in most rules, which is within the discretion of tribunals. And if it's not complied with, then what happens? And that's the big question, actually. Some rules, like the LCIA, would provide that the claim is dismissed or can be dismissed by the tribunal with an additional question as to whether the dismissal is with or without prejudice. In my view, a dismissal with prejudice will be very close to a denial of justice because you will dismiss a claim with prejudice without having heard it, but that's my personal view. You know what happened in ICSID arbitration when one claim was dismissed like this with prejudice, and the tribunal, the other committee, subsequently set aside the award. So here you have an interim measure which has profound consequences on the claim, because the claim will be or may be dismissed if it's not complied with. With this, I will stop there, Isabel, so that we can perhaps discuss or move to the next topic.
Thank you. That was very interesting. I'm going to ask Rafael now. So we know that the interim measures work, and the examples that Philippe said are very interesting and truly exemplify how interim measures work. So what do we need to do to get there? What are the standards that a party needs to meet in order to get interim measures excuse me, from a tribunal?
Thank you, Isabel. And first of all, it's a pleasure to be here, and I appreciate the invitation. It's great to be with you and with Philippe. I would say that I would like to start by simply stating that arbitrations do not take place in this vacuum where there's only the arbitration and that's it. Usually you will have parallel proceedings, multiple legal issues and rights at stake. You usually have states on the other side, or you have arbitration involving states. You have multiple issues that need to be dealt with and that can affect the integrity of the arbitration proceeding and the rights of the parties that are in the arbitration. And this is very important because, as Philippe correctly pointed out, interim measures do work. They are part today of a lot of cases, and there's a substantive amount of cases, a high number of cases dealing with this. But in the end, what we must not lose sight of is that there are cases, because there's a very strong legal regime supporting the issuance and the institution of interim measures. If we were to start simply by stating Article 47 of the Exit Convention clearly states that tribunals, as Philippe correctly pointed out, have the power to recommend measures to preserve the rights of the parties. Furthermore, the Ancestral Rules 1976 clearly state that international arbitration tribunals have a broad authority to take the measure that they deem necessary with respect to the subject matter of the dispute. So again, if you look at this broad context and these broad wordings, you have that legal authority, and tribunals have in many ways the power to preserve not only the rights of the parties, but the integrity of the arbitration proceedings. Now, as to the specific standards, we would like to point out that there's been, or I would like to point out that there's been sort of an evolution, not in terms of the substantive content of the standards, but in terms of trying to have more nuanced approaches as to what are the specific requirements for getting to an interim measure. Usually, if you look before in the 90s or early 2000s, before this wave of reform and trend that Philippe referred to, all tribunals will likely say that there are 5 main requirements that need to be satisfied. First, the tribunal must have prima facie jurisdiction to decide the dispute to decide the dispute. Second, there must be a prima facie case on the merits, and I know we'll discuss that further. But basically, there must be some sort of reasonable possibility that the party requesting the measure will prevail. And then you go into whether the measure is necessary, whether the measure is urgent, and whether the measure is proportional. And if you look at those requirements and in general terms, those standards, there might be some more or some less. It depends on the exact wording. But then if you look at those standards, there's been a clearly, I wouldn't say, again, an evolution, but more of a careful attention as to what are those nuanced approaches that must be relied upon. And there are some important things to notice. So, for example, in 2019, the British Institute of International and Comparative Law and White and Case issued a report on the question of interim measures. And they found, for example, that parties were twice as more likely to get the interim measure if the arbitration was under the ancestral rules as opposed to the exit rules of arbitration. And that usually may happen because there's a belief that uncitral tribunals have a broader discretion as to the sort of measure that they may take. So, for example, again, in uncitral cases, tribunals have may take the measure they deem necessary with respect to the subject matter of the dispute. Now, if you contrast that with exit, which says that there's a recommendation to preserve the party's right, it would seem that it has a more limited and nuanced approach. Now, uncitral did not stop there with that wording in Article 26 of the uncitral rules, but later on, and in the beginning of this century, we had major working groups analyzing both a draft text for the uncitral model law and for the uncitral rules. And from those tests and studies and analysis came Article 17 of the uncitral model law, which is regarded by many commentators as the golden rule in terms of trying to obtain provisional measures. And if you look at that, Article 17 first starts by saying, what are the measures or the objectives that you would like to obtain through an interim measure? So some of those Philippe clearly mentioned. But you could say that then the tribunal has broad discretion to prevent basically any obstacle against procedural integrity of the arbitration. You would say that the arbitration also has the power to preserve evidence that it is necessary for purposes of the case, and also that the tribunal should take into consideration and should regard whether the award could actually be enforced, whether it can actually be complied with. And now, in terms of the standards, what the rules have said, what the Article 17 has stated is that the parties shall state first that it is likely that a harm that is not adequately reparable by an award of damages is likely to occur if the measure is not granted. And if you look at that wording, then we come from a state where parties need to have this likelihood test that if the measure is not taken, then a harm that is not adequately reparable, and we'll get into that, by an award of damages will take place. So we, in a sense, the UNCITRAL model law abandons this necessity test and tells you, let's go into a likelihood test. And when you go into an award not reparable by damages, usually parties will enter into discussions as to if there is an irreparable harm or not. And what is an irreparable harm in that regard? Now, there is, of course, views stating, well, an irreparable harm is simply a harm which of such magnitude that is not likely in any way to be reparable by an award of damages, but that will cause an irremediable prejudice on the parties. Think about procedural issues, the fact that a party may not be able to defend properly himself. The Albania case, the Hydro Albania case Philippe mentioned would be an example of that. But then other parties also questioned, well, isn't that standard a bit too high? Shouldn't we also consider that question of irreparable harm should be a bit more flexible? And then many came to assert, well, perhaps we should regard not that strong, strict standard of irreparable harm, but some sort of substantial or grave harm that could also lower the bar, but could be more reasonable in the scope of investment on and commercial disputes. So think about the construction bond example that Philippe mentioned. That would mean that, usually collecting on that bond wouldn't qualify as a big irreparable harm under the most strict standards, but will certainly constitute a grave harm looking into specific consequences or the specific circumstances of the case at hand. So there's some sort of relaxation there and some sort of view that we should regard to the facts of the case and the consequences and whether a specific damages could be reparable or not. In the context of the exit arbitrations, for example, Burlington and Perenco, Ecuador, clearly stated that measures that would take, that although had economic consequences and could be somehow repaired by an award of damages, shouldn't take place because they could lead, for example, to the insolvency of the investor or to such situation in terms of an imbalance of economic rights that would deem the investor's position clearly will leave the investor clearly in a position where it couldn't assert properly its rights. So those are, in a way, the issues that you may have to find with. Now, the other rule that or standard we should rely is whether there is a substantial harm caused to the party against whom the measure is directed, and whether the harm that is caused to the party, if the measure is not granted, it must be balanced against the harm to the party to which the measure is directed. And here, the key question that UNCITRAL came with is substantial harm. That is there a more substantial harm to the party against whom the measure is directed? And in that regard, then also tribunals may have a bit more discretion in stating perhaps we could affect the party against whom the measure is directed to. But it's not that substantial. It's not that egregious to the point where that party will not be able to exercise or exert its rights. So again, think about criminal proceedings. I take it that telling a state or recommending a state to halt extradition proceedings or criminal proceedings may be viewed by some as excessive. But again, when you compare that in proportion with what's at stake here, the integrity of the arbitration and the possibility of a party to defend itself in an arbitration, then it should sound reasonable. Perhaps the last standard I should regard there is whether there is a reasonable expectation or a reasonable possibility, actually, that the party will preserve on the merits of the dispute. Now, I don't want to get into too much detail because I know we're going to discuss this a bit later on, but the key question is whether the party can furnish or can show that there is a standard. It doesn't mean to be a more likely than not standard in terms of prevailing in the case, but certainly that the party has issued and stated and presented a case that may be, that it is at least possible that it will succeed in the merits. And that is an analysis that arbitration tribunals will usually try not to enter into such detail as in order not to incur in the risk of prejudgment. And perhaps the final standard would be the idea that tribunals need to be certain, or at least need to have that prima facie jurisdiction. And although Article 17 of the UNCITRAL model law does not mention it expressly, it is a standard that usually it's very well established and connected in the context of UNCITRAL and interim measures in international tribunals. So here, tribunal basically has to state that if it's going to issue an interim measure, it needs to found at least a reasonable possibility that it can exercise that jurisdiction, and that's quite important. I will also end with an idea that Philippe mentioned in the beginning of his presentation, but I think it's very important. This wave of reforms in terms of the legal text surrounding interim measures is substantial. And one of the best examples is the latest reforms introduced to Article 47 of the ICSID Convention. Because usually before Article 2, or the current text of Article 47 clearly has two sentences. There's not much content there, but the new wording does clearly develop those criteria. And it expressly mentions the urgency, the necessity, and the proportionality of the measure. So again, there's a legal regime that allows us to request those measures to preserve the rights of the parties and to preserve the arbitrations. And in the end, if we have a system of treaties, of model laws, rules, regulations that seek a view of pro-arbitration, then it is necessary, I believe, or at least it's consistent to think of interim measures as a very essential instrument for purposes of preserving that system. I will end with that, Isabel. Thank you very much.
Thank you, Rafael. That's so enlightening. And one of the questions that I, as counsel, that when I'm thinking about my case and how to present it, and when I need to ask for interim measures, is the identity of the arbitrator. And a lot of factors play into that. But I'm wondering whether, what do you think is the influence of the common law versus the civil law systems in the international arbitration regime, not only with respect to the arbitrator, which is evidently one very significant point, but more broadly in the context of interim measures in general? And do you see it play out? Do you see that there's a difference between the two or that the two affect interim measures in different ways? And if so, how and where? So this is a question for both of you. You both have different experiences. I think I'll start with Philippe, and then we will turn it over to Rafael.
Thank you, Isabel. If you have to ask yourself whether the common law, civil law background, being the background of the arbitrators of that of the applicable law to the contract as a bearing, you must first look at the source of the authority to order interim measures. And the source is, in my view, inherent in the sense that some jurisdictions take the precaution of, saying expressly that arbitrators cannot render interim measures, like Italy, for some measures. So it means that otherwise, but for this prohibition, they would be entitled to do so. But most of the time, the source is the agreement of the parties as expressed in the applicable arbitration rules. So it's the UNCITRAL rules, if it's ad hoc, or the ICC rules or the ICSID rules. Now, if you look at those rules, they define the situations in which interim measures can be ordered and the criteria to be used. They are more or less prescriptive. We can come back to that. In my view, the less they are, the better, although the recent evolution seems to demonstrate once again that people are afraid of their own liberty. So they prefer to have a very strict normative text rather than to have a discretion. I personally prefer the discretion, but that's a different topic. But coming back to your question, the divide that I see is not so much among civil law or common law practitioners, but among specialists of international arbitration and people who say do arbitration from time to time and come with a domestic background, because there you will see a lot of influence of the approach to interim measure that exists in the jurisdiction of generally the presiding arbitrator. And of course, if you have somebody who practices essentially, I say in Germany, for example, then that person will be influenced by the test applicable before German courts. By contrast, if you have a German arbitrator that practices international arbitration all the times, the approach will probably not be different whether it is a civil or common law practitioner. It may be that individuals will have different approaches, as I say, but not so much based on their background, because once again, the authority to order interim measures is not found in the law that governs the contract. It is a separate authority which has its own criteria and which, in my view, operates at the international level. So you have that power or not if it was removed by the legislator, but if it's not removed, you have it. And how you exercise it depends primarily on the manner in which interim measures are approached by the applicable arbitration rules or by the law of the seat, potentially, which will tell you the measures that you can render, how you can render those measures, and what are the criteria to render those measures. So in my view, really, this is detached from the law governing the contract. It's a separate power, which is based on set of norms that apply across the board, be it civil law or common law governing the contract. I will maybe stop there and give the floor to Rafael for any additional thoughts he has.
Please go ahead, Rafael.
Thank you, Philippe. I agree with everything you said. I would say that I've had interesting experiences when dealing with lawyers in both civil law and common law. But I would say that the main differences that I found interesting is the fact how civil lawyers disagree between themselves and how common lawyers sometimes disagree between themselves, particularly in two subjects. I remember a case when I was working on that involved common law lawyers, British perspective and the US perspective. And there were, I guess, a lot of differences between them as to the standard of proof and the so-called the balance of probability and what facts should actually be demonstrated to the tribunal for purposes of getting the interim measure. And I found that fascinating in a way, because although I agree with you that we have the international standards and that we need to really create this transnational system of international arbitration and enhance this system, it's usually the case where the law of the seat or the local laws and the local cultures will get in the way of some arguments made by lawyers. And so, for example, this was a US seated arbitration, and I remember the parties relying the US parties relying strongly on the case law made by district courts and federal courts involving that specific jurisdiction as to what, for example, is an irreparable harm and the specific facts that must be proved for that purpose, even though this was at least the state that adopted the UNCITRAL model law. So again, I see that difference, and I believe that still local law has some issues to rely on. In the question on or at least the lawyers rely on local law, and that is something that we definitely need to put more attention to. I'm not saying that it's a correct approach, but I guess that the key issue is whether we can balance the international standards and specifically what are those provisions of the seat that the parties or the lawyers must rely upon. Now, in the case of civil lawyers, I found at least a case where there was a big discussion as to what constitutes the irreparable harm. And it was a case whereby a party was requesting basically that a state refrain from taking certain actions against a contractor. Because the arbitration started, the state initiated sanctionary proceedings or punitive proceedings in that regard. And basically, the contractor said, listen, if you go forward with these proceedings, which are directly related to the case at hand, then it is likely that you can unilaterally terminate the contract, and that would be an irreparable harm. And on the other side, the lawyers from the state said, well, that's not an irreparable harm under civil law. An irreparable harm under civil law is simply something that you will not be able to obtain through an award of damages, a very strict case. And here, if the contract was wrongly terminated, you will have that option to discuss in the arbitration, and you can request compensation for that. And there was a strong discussion there. And clearly, these were arbitrators from civil law backgrounds and the context, and that was a big issue. Now, I'm happy to report in that regard that the concept of irreparable harm was adopted by this arbitrator was flexible, and it regarded the termination or basically the idea that the contractor rights were not going to be preserved during the arbitration amounted to an irreparable harm, or at least amounted to an award that could not be adequately compensated by an award on damages, and that it was grave and significant. Now, I've seen a tendency now in some Latin American jurisdictions whereby this concept of the irreparable harm dealing with civil law and common law backgrounds has been so flexible that I recently saw a decision whereby the tribunal issued the measures only by the party showing that there was a risk of an irreparable harm. So here it's not that it was likely, but that there was a risk that such measure could take place. And I found that I find that very interesting. So I would say that the main difference will be subjects regarding the standard of proof and the role of the law of the seat in these international standards, and definitely the question of irreparable harm. That is something that I will find that in those subjects that you will find a lot of differences there.
Yes, and if I can add something, Isabel, one aspect where there is a difference, but it's not civil law, common law, it's English arbitrators versus continental arbitrators. I say that because I explain in a moment that Singapore has a different view on this. It's about performance bonds. Traditionally, English arbitrators are less likely to intervene and ask a party not to exercise its right to draw the bond. The orthodox view, like 30 years ago, was that arbitrators didn't have jurisdiction to do that because the bond is a separate instrument. Of course, that is not correct, because you can ask a party to the arbitration not to exercise a right under a separate instrument. You're not judging anything about the instrument, you're not adjudicating rights under that instrument. You take them for granted, but you say you do not exercise those rights. So it's not a jurisdictional issue. But nonetheless, there is this notion that performance bonds are like performance guarantees, the lifeblood of commerce, that sort of thing. And you do not intervene, while continental arbitrators are more likely to intervene. And in my view, that is probably a more appropriate approach, depending on the circumstances, of course, because a performance bond is not a payment instrument. It's a guarantee, eventually, for a debt that will be, let's say, materialized when the award is issued. So it's not the equivalent of money. And there is a decision, I don't have the name of the case in mind, in Singapore, that says exactly just that about a performance bond. It's not equivalent to a payment instrument. And this is why I believe it is not inappropriate, if circumstances so warrant, sometimes to intervene in a performance bond. I'll stop here because I see that the clock is running.
Yeah, let me ask you that, we could speak about this for a whole panel. But let me ask you one question that often advocates struggle with in trying to formulate their request for interim measures, which is the balance between establishing a prima facie case and the risk of prejudgment. Can you talk a little bit about that, Philippe, just briefly, since we're almost at the top of the hour, and specifically to the point of to what extent does the risk of prejudgment prevent the arbitrators from issuing the relief that's actually very useful to the parties? Where is that balance, and how does that play out?
That is a difficult question because, I mean, let's face it and let's be honest and candid. If you assess the prima facie chances of success, you are prejudging. That's the very notion of assessing the prima facie chances of success. So the way out for most arbitrator is to add prima facie at the end or the beginning of each paragraph, saying, I'm not prejudging because it's prima facie, meaning I can change my mind on this. Fair enough. If that's the test, that is correct. But in fact, you are asked to assess at a preliminary stage the merits of the underlying case. And if that is part of the criteria that you should apply, like, for example, in the antitrust rules as they've been modified in 2010, the reality is that you're probably prejudging. The only way out is to find a different test to apply, if I'm absolutely candid. If you do not want to prejudge, then you cannot assess the prima facie chances of success. And therefore, you have to resort to another test. But you have to be in a situation where the rules allow you to do that. For example, the ICC rules, where it's discretionary. And in that case, you can adopt a different criteria. For example, you can say, I will look at the balance of convenience. I will look at the situation of the parties and their right, if the measure is granted. And I will compare that situation with the situation of the parties and their rights if the measure is not granted. And I will make a balance between the two and make my choice. This will avoid prejudgment. Otherwise, I'm afraid you have to prejudge. But the only thing that you can tell the parties, and I'm absolutely convinced that all tribunals are honest about that, is that this is a prejudgment that is, for the time being, it can change. Now, there is another thing, another aspect of prejudgment, which is perhaps less obvious but more dangerous, is when rendering the measure, you in fact interpret a provision of the contract that is disputed between the parties. And that interpretation may be done in an incidental fashion. So it's not strictly necessary to your reasoning, but in passing, you make a comment on the way a certain provision of the contract is to be understood. And that may contain prejudgment much more actually than the prima facie example that I gave. And we see that from time to time in interim measure decisions. And I genuinely believe that a tribunal doing that is simply sending a message to the parties saying, look, this is the way I interpret your contract at this point in time. Please pay attention to this and take that into account when doing the merits. So again, it may not be full prejudgment in the sense that tribunal may change its mind, but nonetheless, it is a message that is sent to the parties through a discussion on interim measures that may or may not necessitate this interpretation of the contract. So very often parties do not pay attention to this. I suggest that they should, because when a tribunal does that, they generally do it on purpose.
Thank you for that very candid explanation. I'm going to turn it over to Rafael for probably our last question of the day, and it has to do with what happens when the measure is not granted. And so what is, can you talk a little bit about the standard of proof and the realities of establishing, in particular with respect to the standard of proof, for establishing whether harm not adequately reparable by an award of damages is likely to occur in the event that the measure is not granted?
No,
then what?
Thank you, Isabel. If I just may add one point to Philippe's previous intervention, which I've found very interesting. I agree with Philippe's view on the question of prejudgment. And I've seen some sort of a worrying trend in some cases whereby arbitrators decide that in many ways the prima facie standard is so low, then simply they relax it to the extent where they say, okay, so this is a feasible show of, the claims are plausible. But by relaxing that standard, they may be incurring or giving certain interpretations to the parties that may affect the merits of the dispute. And I believe that to the point Philippe was making, that's very important. We need to look out for that, because usually in those cases, the arbitrators may be prejudging, not I wouldn't say prejudging on the merits, but signaling to the parties, this is the way we're understanding your case. And then by relaxing those standards, we feel that perhaps a point that should be debated furthermore will be, perhaps might be settled in that instance, and that shouldn't be the case. As to your question, though, and the question of irreparable harm, there is I found an interesting case or an interesting experience in the Sergei Viktorovich Pugachev case, whereby the investor against the Russian Federation, whereby the investor requested the tribunal to basically first request the state, order the state to halt criminal and extradition proceedings. But it also requested the tribunal to order the state that some sort of the execution of civil liability judgments that were issued in multiple jurisdictions should also be halted. Generally speaking, the investor claimed that by enforcing those civil liability judgments, the investor will be deprived of resources and its rights will be affected, and it will materialize the specific expropriation or violation of standards that the investor was requesting in that area. Now, I found that despite the analysis that we've discussed, there was a big issue here as to what is the extent under which a tribunal may, in essence, decide upon the question of whether there is irreparable harm. So first, as to the extradition proceedings and the criminal liability proceeding, the criminal proceedings, there is definitely the tribunal took the view taken by the Hydro versus Albania case and by other tribunals in that regard. Some tribunals also involving Ecuador, whereby it was necessary to halt the extradition proceedings and to, in a sense, suspend them until a decision was final in the arbitration, or until the arbitration ruled on the merits or on its jurisdiction. But then the question came, what do we do with the civil liability proceedings? I mean, how much is that the enforcement of a civil liability proceeding, how much is that a irreparable harm or a harm not adequately reparable by damages, by an award in damages? And here it was interesting, and I believe that the tribunal issued an award where it said, listen, there are civil liability proceedings in the Russian Federation, but these liability proceedings have also been reviewed by other courts in different jurisdictions. And there was an example in the UK whereby a court reviewed that proceeding and found that all the measures were somehow consistent and were fulfilled. And the tribunal then gave some deference as well to the rulings of the courts that were involved in those specific proceedings. And I find that necessary, because if we seek to preserve the integrity of the international arbitration system, then international arbitration tribunals should also be mindful of the fact-specific case, or the facts specific to one case, but also to the rulings and the considerations made by foreign courts. And in this regard, there were several rulings by other foreign courts that, in a way, could, in a way, the tribunal said, "Listen, I cannot disregard what they are saying in terms of the value and the legitimacy of these rulings." So I believe that there's also a question that the tribunal should act carefully, analyzing the facts of the case, but should also give some deference to the terms of whether foreign courts, that is, courts not pertaining the jurisdiction of the respondent state, but what are those courts saying and what is happening in those jurisdictions. And I found that, to me, quite interesting, and that's quite an interaction between international arbitration tribunals and other courts of domestic jurisdictions.
So we have about 10 minutes left for this panel, and I want to ask Philippe for his any parting thoughts. You've obviously written on the subject of interim measures, and I'm hoping you can enlighten the audience and all of us with anything that you think we should know before we close this panel.
Happy to. I would just make a comment for those who are drafting applications for interim measures, and I'm thinking here of perhaps the most junior lawyers were tasked with this very difficult task, actually. Just don't be mechanical. Think about the measure that you want, why you want it, and be realistic. If you want to obtain something absolutely and it's necessary, for example, asking a party to continue to perform the contract pending the arbitration, then focus on that and don't add additional requests which will be simply denied because they are unrealistic. And the other thing, when I say don't be mechanical, don't believe that you have to tick all the boxes. For example, urgency is very often not required. Urgency is required when you have access to emergency arbitration, because very often it's a threshold issue. You have to demonstrate that the emergency arbitration is necessary because you cannot waive the constitution of the tribunal. But if you have a tribunal in place, urgency may or may not be necessary. So don't try to demonstrate urgency if it's not necessary. Look at the rules, whether it's discretionary or not, the awarding of interim measures. Play with them. Use the liberty that is afforded to the tribunal to advance your case. So that's very important. Similarly, don't try to demonstrate irreparable harm if there's no irreparable harm. The reality of this test is that in international commerce, with parties that are solvent, it will never be satisfied if you say it's irreparable harm. And Rafael showed very clearly that the test is relaxed, precisely because the test cannot be satisfied if applied strictly. And actually, the antitrust rules do not say irreparable harm. They say harm that cannot be adequately repaid in damages, which is not exactly, or I would say not at all, the same thing. So just be very careful with the criteria, with the authority of your tribunal when drafting your request. Don't set the bar too high. That would be my advice, if I can say so. Try to satisfy what is needed, but just what is needed, no more.
Rafael, any parting thoughts? You're on mute.
I would just add that in light of Philippe's comments, it's also very important to be very clear, precise on the facts that you're currently alleging and that you can actually prove them. Sometimes some requests rely on a lot of assumptions, inferences, possible adverse situations that may arise. Focus on the exact facts that are triggering this request. And I believe that that's key for purposes of giving the tribunal giving the tribunal the sense that they have the power to request a measure. That's something that is key, and I believe that if you based it on the facts and the conduct of the parties instead of assumptions and inferences and what may happen if I don't get the measure and I have the feeling that this will happen, usually that's not very helpful when drafting those requests. But other than that, those are final comments. Thank you very much, Isabel and Philippe.
I will add one final comment to that, which is that as advocates, we know the record really well, and we want to make sure the tribunal understands every single detail of every single fact and every single point of law. And we all think that each and one of them is very important. And the reality is that tribunals only have a certain span or capacity to understand those facts, to understand the law, and to observe it all. And so one of the most important advocacy skills that I think is required of an international arbitration tribunal, international arbitration advocate, is the ability to simplify, to go to the key point, to go to the heart of the matter of what are the relevant facts, what do you need to win what you're asking for, what's the relevant law, and separate what's relevant to what's not relevant, what's the tribunal going to care, what's the key, what's the essence, and just focus on that. And then ignore the rest, because even though it may seem very important to you, at the end of the day, if the tribunal does not need it in order to decide the issue, then it's wasted space in a brief. And I think with this, I think we can conclude this panel. Thank you very much, Philippe and Rafael, for your insights. And I will thank you to Harvard for inviting all of us. And I will turn it over to Sebastián and Karim for their final remarks.
Thank you so much, Philippe, Rafael, and Isabel, for this truly fascinating discussion that went beyond discussing current trends. Thank you for questioning the current tests applied by arbitral tribunals. And I wanted in particular to thank you for even going as far as to suggest a new test to be applied with respect to interim measure requests in international arbitration. It was truly thought-provoking, and I very much enjoyed it. Now, on behalf of the entire executive board of the Harvard International Arbitration Law Students Association, I want to thank you once again for accepting our invitation. We are honored to count you among us this year, and we sincerely hope to host you in upcoming HIALSA events in the near future. We will now have a 20-minute break and come back at 11:30 EDT for a panel discussing different trends with respect to enforcement of arbitral award. See you all at 11:30 EDT. Thank you so much.